I'm Pat Peacock. I'm here today to present the Protecting Yourself and Your Family portion of Financially Fit Aging for you and your parents. We have experience in these areas, but do not profess to be experts. We want to provide an overview that gets people thinking about these issues and topics and having conversations about them, as well as to provide direction to gain further knowledge, information, and resources. We're going to go through two pieces: the what to do while you're still alive, what to do after you're dead. So, protection during incapacity, that's during your lifetime; protection for your family after your passing. So, when you're incapacitated, you need somebody to take care of your financial affairs. And one way to do that is with a durable power of attorney. It needs to be durable so that it continues on after your incapacity. You set up the power of attorney, you have an agent who's going to act for you. You can set that up so that the agent can act for you now, whenever, or you can set it up so the agent can only act for you after a certain thing happens. So for instance, it won't become workable or valid until you are actually incapacitated. There have been some recent changes in Colorado to powers of attorney. So if your document is older than January 1st, 2010, you definitely need to have it reviewed by an attorney, but you should review your documents about every 5 years anyway. So either way, it's time to take a look at your power of attorney if you already have one. The other thing, if you're incapacitated, that you're going to need is someone to make medical decisions for you, and that's the medical power of attorney. There are two pieces really to an advanced healthcare directive: the medical power of attorney, and then what's known as the living will. So some lawyers will put the medical power of attorney and the financial power of attorney into one document, and others will make them two separate documents. You don't have to have the same person as agent for both. You can have one person taking care of your money and another person deciding your medical decisions. So a good medical power of attorney, your agent has access to your medical records. They can make decisions, including the DNR, the Do Not Resuscitate order. Again, this is a little older, so hopefully there's not a lot of these out there, but if your medical power of attorney is older than January 1st, 2005, it should be reviewed to make sure you have appropriate HIPAA language in it. Otherwise, parts of the older ones are not necessarily being honored, depending on the institution. This also gives the agent some postmortem authority, like getting you buried or cremated. The living will only applies if you're terminal or in a persistent vegetative state. And this document gives your agent the authority or the power to direct pain medication, nutrition, and hydration. And this is one where you can kind of check the box. A lot of them have a check the box: I want to be fed for 10 days, 3 months, not at all if something happens. So those are all things to think about before you go to the lawyer to get these. There are, you can go out on the internet and get pro forma documents, but I do not recommend doing that because everybody's situation is different. And if you go to an attorney to have your will or your trust updated, they usually automatically take a look at your powers of attorney to see if they also need an update. So that covers the living part of the program. Now, once you pass, you want your assets to go where you want your assets to go. There are several different ways of transferring title on assets after you die. One is joint tenancy with right of survivorship, so joint ownership. One is through beneficiary designation. One is through a will, and you can also transfer property through a trust. Here's the thing about joint tenancy with right of survivorship. By operation of law, if one party dies, the other party automatically becomes the full owner, if you've got two parties here. That supersedes the will. So anything that's in joint tenancy will not pass through your will. So what I've seen happen is people get these elaborate, really great estate plans, have everything in place. Somebody, honest to goodness, at a cocktail party says to them, if you put everything in joint tenancy, you can avoid probate. They run around and put everything in joint tenancy with their spouse. And so they have totally blown their estate plan. So if your financial situation is complicated enough that avoiding probate is important, there are other ways to do it and still have your estate plan work, and we'll get to that in a minute. The other thing about joint ownership, joint tenancy, is if you are a joint tenant with someone who's not your spouse, you could have a taxable gift. And so what happens is somebody will put their adult child, on their checking account as a joint tenant instead of using a power of attorney. That child as a joint tenant has the same rights you did. That means they can withdraw the whole account. Constructive receipt, it becomes a taxable gift. So before you do anything like that, you want to see if that's going to be an issue in your estate. Another way property passes is beneficiary designations. Most of the time you see these on life insurance policies and retirement plans like 401ks, pensions with a surviving spouse, or IRAs. You can also sort of have a beneficiary designation on your bank accounts and your brokerage accounts by using the POD and the TOD, which is pay on death or transfer on death. But again, these are things that supersede the will. So anything you set up with a beneficiary designation or a pay on death designation is not going to pass under your will and under your estate plan. It's going to go directly to whoever you've named. So you just need to remember that. The other thing I would say about beneficiary designations is you should, every 5 years while you're checking your documents, or more often if necessary, check your beneficiary designations. I've seen cases where the company went through a computer upgrade and the beneficiary designations were wiped out. So you want to make sure they're still there, just as a matter of good planning, really. Especially like on an IRA account, if there's no beneficiary, it's going to go through your will. So you have an IRA account, it will have to be probated. And you lose the benefit of the tax benefit of stretching that IRA to a person's lifetime, and you're stuck with a 5-year. If it has to go through your estate, you're stuck with having to pull that IRA out within 5 years. If that's most of the estate, you're going to have big chunks of taxable income with not a lot of control over when you receive it if you don't have that proper beneficiary designation. So talk to your attorney and talk to your tax advisor if you're not your own tax advisor. A will is a legal document. It's governed by state law. So if you've moved from another state and your documents were made in that state, if you plan to die in Colorado, you should have your attorney look over the document to make sure it will still do in Colorado what you wanted it to do. Usually the biggest differences are if you're going from a community property state to a non-community property state or vice versa. The property passing under a will has to be probated. The whole purpose of probate is just to change the title. So it's sort of an orderly process to move assets from the decedent to whoever they should be moved to. If you have a will, then you get to say who they go to. If you don't have a will, then the state of Colorado says who they get to go to. The person who carries out the terms of your will is called an executor or a personal representative. In Colorado, it's a personal representative. Some states still use executor. You can also use a revocable trust to transfer assets. There are a lot of different kinds of trust, but for our purposes today, the only one we're going to talk about is revocable. So the way it works is you have a will, and what your will says is, Everything that I did not get into my trust during my lifetime, put it there now. So it's a pour over will. And so all of your assets are gathered into the trust, and then the terms of the trust determine who gets the assets. It's set up during your lifetime. You have a grantor, also known as a settlor or a trustor, transfers property to a trustee for the benefit of a beneficiary. While you're alive and have capacity, you can be the grantor, the trustee, and the beneficiary. You can play all three roles. Because this is a trust that you can change anytime you want to, you can revoke it anytime you want to. And so for that reason, the assets in a revocable trust are taxed back on your own tax return, your own 1040. At your death, the assets in this trust would get a step up in basis, just as if you owned them outright. But this is a fairly complex area, so there are resources where you can get more information, but do talk to your legal advisor or whoever is helping you with your estate plan about whether a revocable trust is appropriate for you. But it is one way to pass title. One thing that a lot of people forget about is digital assets, because they're just such a part of life anymore. We don't even think about it. We don't get paper statements anymore. So if we were to die, would somebody know where all of your accounts are? Would somebody be able to get into your computer to see your financial records? Would somebody be able to get into your house and get past your security system? So those are passwords and access that you want to grant to somebody some way. There are different ways of doing it. You can make a list on a piece of paper with a pencil of all of your accounts, and remembering all of your accounts can be a challenge too. So you have a Facebook account, a Twitter account, an Instagram account. Maybe you have cash left in PayPal that your personal representative would want to bring into your estate. You have an account on iTunes where your music is, all of those things, Facebook. The social media accounts all have different policies for what happens when someone dies. And Facebook's actually been sued a couple of times for not releasing information. But most of social media, it's a license agreement, and so you don't really own the account. They get to control what happens. So you want to check into that. The easiest way is to make sure somebody can access. I know what Facebook does is they will set the account so that nothing more can be posted to it, but that people can go out and get photographs and that kind of thing, which is what usually people want to do, because everybody's photographs are now somewhere online as well. The other things to think about to make sure your family's protected, and if you have a partner, you need to discuss these things with your partner, is if you have minor children, who will their guardians be? It's also a good idea once you make that decision to discuss it with those people, because they may not want to. A lot of people don't. It's a surprise. Guess what? You're getting 3 kids. Who should take care of these affairs for you if you're incapacitated, if you are deceased? Who should be your personal representative? So that's the person who settles your estate. Who should be your trustee? That's a person who's going to have ongoing responsibility if you have set up a trust or if your will creates a trust. Should your trustee be an individual, like a family member or a professional? There are private fiduciaries. I've seen both attorneys and CPAs be trustees for clients. Corporate trustees, which are usually bank trust departments. The advantage to that is they don't die, they're still there. The disadvantage is they don't know your family. So another thing to discuss with your legal advisor as you're setting these things up. Who would be your final heirs? If there were nobody left to inherit, who should the money go to? your heirs at law, which would go down to like second cousins or a charity. That's something to think about. And if you have charitable intent, if you want to make sure your favorite charity receives money at your death, this is the time to think about that and how you want that to happen, whether it's ongoing or one payment. So these are all the things these are the questions you should be prepared to answer when you go to the lawyer's office. So the last thing I would say is people don't want to talk about this. People don't want to face their own mortality. It's really difficult to get people to sit down and think about what they want to happen, because then they have to think that they won't be there or that they will be incapacitated, and it's scary. But the thing is that for CPAs, clients see a CPA much more often than they see their attorney. So if we can have those conversations with our clients and with our own families, the best thing you can do for your family is have your affairs in order. I've seen cases where young families, in one case, the parents were killed in an automobile accident. They left an 11-year-old son and no will. There were $2 million in life insurance proceeds and then Social Security survivor benefits for the son. And the family, the two sides of the family just went at each other who was going to be guardian of this child, because they thought they were going to get the money. So you can save all of that. You can save the rift in the family by having everything set up ahead of time. There are some resources that will give you more in-depth information about what we've talked about today on the web. Or are there any questions?
Out of curiosity, do you know when you say if you don't have a will in place, the state decides who gets it? Do you know if I assume there's some sort of process for that?
Yeah, it's called intestacy, and who gets your money depends on what your situation is. So in a situation where you have a married couple, it's the children are the children of that marriage. There are no his, hers, and theirs. The spouse would inherit everything. In a situation where you have a second spouse, so you have children by your first marriage, children by your second marriage, and a new spouse, then the statute determines, so the spouse can get, in that situation, would get up to 50% of the estate. And when I say up to 50%, depends on how long you've been married to that person, determines what percentage they get, and then the balance would go to the children.
So it gets complex.
Yeah. Yeah, anything that's outside, the Leave It to Beaver, Ward and June kind of box is going to be fairly complicated. So another reason to have a will.
So when you talk about probate, is there some kind of dollar limit that people are under where the state doesn't have to get involved?
That's a really good question, and the answer is yes. There's a small estate proceeding. You still have to change title, which is what the purpose of probate is, but you don't have to go through a probate where you're filing reports. Probate requires you to file an inventory and an accounting for the estate and to send things to all of the heirs and so forth, and you pretty much have to have an attorney to do probate because you do appear before the court when you open it, a probate, and when you close it. You can do non-appearance, but you're going through the court. On a small estate proceeding, there's a form you can use. It says this is the way it is. You can fill that out and attach a death certificate, and usually that would be sufficient. So what happens is people may put all of their assets in a revocable trust because the trust doesn't go through probate, but they keep the car out. So you need to transfer title on that car. You can take the small estate affidavit, the death certificate, go to motor vehicles, and transfer the title. Does that answer?
Yeah, I think that's how I did it when my dad died. It just seemed like I was sending his death certificates and a copy of his will to everybody.
Yeah.
It said he left everything to me.
Yeah, as long as it's not real estate and it's under a certain amount, and I think the current amount is $56,000, but don't quote me because it changes from time to time.
You mentioned there's several ways to transfer ownership if I were to pass away, beneficiaries or through, the will. What are the advantages of using beneficiaries versus the will?
Well, if you use a will, it has to go through probate unless you're under that amount, that small estate amount. So there's a cost associated with that. Without probate or without the will, if you have everything, either a beneficiary designation or a joint tenancy, then you don't have an estate essentially, because everything's going to pass directly to those people. But remember, somebody's going to have to pay your final bills. So if you have more than one person getting your bank accounts, who's going to write those checks? That sort of thing. So
Especially if somebody dies of a terminal illness, the bills keep coming for a really long time.
Yeah. That's a really good point. They do keep coming for a while. So does that answer your question? I do know a lot. I've seen people who have done it that way, and it's worked. The kids got along well enough to write the checks and pay the final bills, but it doesn't always happen that way. Any other questions? Okay. Thank you.